Welcome back to this final segment of the law session on contract law, duress and undue influence. Now, just before the break, I explained what you would look at when you're determining Class 2A presumed undue influence. And just before the break, I told you we'd be going into looking at establishing the presumption under Class 2B. Now, under Class 2A, we see an automatic presumption, but under Class 2B, we see a presumption which has to be proved. So, Class 2B, there is no automatic presumption which arises as a matter of law. Here, it must be established that there is a relationship of such a kind that one party, in fact, placed their trust and confidence in the other to safeguard their interest. Now, any relationship is capable of amounting to this example, including husband and wife, cohabitees, employer and employee. The important distinction between Class 2A and 2B is the fact that the trust and confidence relationship must be proved. Now, in modern times, it is no longer the case that wives will generally place all their trust in their husbands to deal with the financial matters, although in some marriages this may be the case. Now, if the wife exercises independence of mind in financial matters, then no presumption will be established. Case in point, of course, is Barclays Bank and O'Brien. Now, this is a case I do urge you to read. There are two cases which are pretty important in this area. I've already flagged up the Royal Bank of Scotland and Etheridge case, but Barclays Bank and O'Brien is really where we see a lot of this making some degree of sense in terms of giving you a basis from where to start. Now, Mr. O'Brien was a chartered accountant, and he also had a shareholding in a company in which he was an auditor. The company was experiencing financial difficulty, and the bank wished to find security for the company's debts. Mr. O'Brien offered the matrimonial home as security. He told his wife that the charge was limited to £60,000 and that it was only to last for a few weeks. Now, initially the wife refused to sign it, but was later persuaded to sign it, as the husband told her that the company would fail if she did not, and that her son, who also had an interest in the company, would lose his home. In fact, the charge was not limited in the amount or the time. The wife agreed to sign the charge. The manager of the bank had sent the documents to their local branch with instructions that the wife was to be advised of the full extent of the liability, and the wife should be advised to take independent advice before signing. So he made sure that he left instructions telling them what they needed to do. However, the bank clerk got the wife to sign and failed to carry out the instructions. Well, the bank sought to enforce the charge, and the wife raised undue influence and misrepresentation in her defense to have the charge set aside. Now, the defense based on undue influence failed because the wife was held to exercise independence of thought on financial matters and was used to dealing with the family finances while her husband was working away. The wife was successful, though, with regards to the misrepresentation. The charge was set aside as the bank had constructive notice of the misrepresentation and failed to take reasonable steps to ensure that the charge had been obtained without influence, or that Mrs. O'Brien was aware of the full extent of liability. Lord Brown Wilkinson introduced the concept of constructive trust and set out the steps required to be taken by banks to avoid being fixed with constructive notice. He said, therefore, in my judgment, a creditor is put on inquiry when a wife offers to stand surety for her husband's debts by the combination of two factors. The first being the transaction is on its face not to the financial advantage of the wife, and second, there is a substantial risk in the transaction of that kind that in procuring the wife to act as surety, the husband has committed a legal or equitable wrong that entitles the wife to set the transaction aside. It follows, he said, that unless the creditor who is put on inquiry takes reasonable steps to satisfy himself that the wife's agreement to stand surety has been properly obtained, then the creditor will have constructive notice of the wife's rights. What then are the reasonable steps which the creditor should take to ensure that it does not have constructive notice of the wife's rights, if any? Normally, the reasonable steps necessary to avoid being fixed with constructive notice consists of making inquiry of the person who may have the earlier right, which is the wife, to see whether such right is asserted. It is plainly impossible to require of banks and other financial institutions that they should inquire of one spouse whether he or she has been unduly influenced or misled by the other. But, in my judgment, the creditor, in order to avoid being fixed with constructive notice, he said, can reasonably be expected to take steps to bring home to the wife the risk she's running by standing as surety, and to advise her to take independent advice. Here's a question. Does a relationship of trust and confidence exist between a bank manager and his client? We will consider this further. Well, exceptionally, it has been held that a relationship of trust and confidence existed between a bank manager and his client. But in Lloyds Bank and Bundy in 1975, we see where a father secured the debts of his son's business on his farm, which had been in the family for generations. Now, the father and the son had both banked at the branch for many years and relied on the advice given. Now, the son's company also banked at the same branch, and the bank manager was aware of the dire financial position of the company. The bank had allowed the son to run up an overdraft exceeding the security given, and this was far above what was agreed, and they were fearful that the company would go under, leaving them with an unsecured debt. So what does the bank do? The bank manager and the son called at the farm with the forms already filled in. The father was told of the amount of the charge, which was about £11,000 and exceeded the value of the farm, and he was also required to give a guarantee. The father agreed to sign in order to help his son. He was not given the opportunity to think it over or to obtain legal advice. Now you can see exactly where the court's going to go with this. The court said there was a relationship of trust and confidence between the father and the bank manager, giving rise to a presumption of undue influence under the Class 2B. Now, this is the kind of case that would give rise to a set of facts in an exam question, because the point is that a bank will not normally be in a relationship for a Class 2B. But here, where you see that the bank was not just your typical bank on the high street or in the city center, the minute you're going to talk about a bank manager with a person going down to a farm, I'm not sure I know any bank manager nowadays who would pick themselves up and go to a farm, but there it is. It gives you some idea of the relationship, and therefore if the banks have to, or the bank itself has taken on board acting in this capacity, then it may find itself sized with some degree of influence, and that is what the courts looked at here. The charge and the guarantee were set aside by the court. Now, the normal relationship, as I said, between a banker and a customer is not one of trust and confidence, so do not use this case to say that. It simply shows that if you take the relationship to one of trust and confidence, the court will consider it as such. So, it's not normally the case, but a business relationship whereby the bank is looking out for its own interests, and of course, you've seen that in NatWest and Morgan. However, the bank manager, in giving evidence, did admit that the father implicitly relied and solely relied on the advice given him, and the father stated that he had trusted the bank and had a long relationship with the bank, and he generally acted on their advice. However, it has been held, as I say, that the normal relationship is not like that. Now then, Class 2A and Class 2B as it relates to relationships which give rise to a presumption. How do you rebut the presumption? Well, the party accused of exercising undue influence may rebut the presumption by demonstrating that the vulnerable party exercised free will in entering the transaction. Now, this is most commonly established by showing that they were fully aware of the risks involved and had received legal advice before agreeing to the transaction. And if you look at the undue influence, for example, and when we start from the standpoint of third parties, generally the undue influence is exercised between the husband and the wife, and where a wife establishes undue influence, it will entitle her to have the transaction set aside as against her husband. However, the transaction is generally with a bank who was not a party to the influence. Now, following the decision in NatWest and Morgan, it became clear that banks were not acting in a fiduciary capacity so as to give rise to a presumption of undue influence. There had to exist, the court said, another factor in order to have the contract set aside as against a bank. Now, in Barclays Bank and O'Brien, we see that there they introduced the concept of constructive notice. Now, constructive notice arises where the bank is 1. Put an inquiry, and 2. Fails to take reasonable steps to ensure that the transaction was entered freely without the exercise of undue influence. Now, two very important cases, I say, that you must consider whenever you are anticipating preparing for this particular area are, of course, Barclays Bank and O'Brien and Royal Bank of Scotland and Ettridge. They do look in depth in this area. They are very important, as I say, because we see that the courts have now taken a more pragmatic view, in that whilst it is that you will not find the court saying, well, if you've got, for want of a better word, an intelligent woman dealing with a situation in front of them, they said, look, if it is that you knew what your husband was doing and you are of independence of thought in financial matters, we're not going to fine for you. And certainly we see that if the banks themselves have in place a particular system and procedure, then they will not have liability attached to them. In recent times, we see that these have by and large been taken on board. So these types of cases have become less and less in recent times, and certainly the high watermark is in Ettridge. I would urge you to look at Ettridge. That covers this area and certainly this session on duress and undue influence, and I would ask you to join the next session in this contract law series.